Data protection and privacy teams are under more pressure than ever with new laws, AI oversight, data breaches, and the constant expectation to do more with fewer resources.
That's why TrustArc built a modern privacy and data protection management platform powered by Arc Intelligence. It unifies your tools, automates the work that slows you down, and surfaces what matters most right when you need it.
From guided quick actions to our intelligent assistant, Ask Arc, you get credible, contextual answers backed by expert research, not generic AI guesses.
Finally, privacy that works the way privacy pros work.
Learn how TrustArc helps teams move faster with confidence at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.
You're listening to Serious Privacy by TrustArc. Please welcome our hosts, Paul Breitbarth and Kay Royal.
Just when we thought we had reached the end of the US legislative season and could no longer expect any more state privacy laws, the great state of Colorado surprised the world by wrapping up their legislative debate. On June 8th, the Colorado Senate, in an almost unanimous vote, approved the bill as amended by an almost unanimous House. The Colorado Privacy Act will become law if Governor Jared Polis will sign the bill within 30 days, so by the 8th of July. Or if he lets it ride, meaning he just does nothing. And a veto is not expected at this time. So, after the CCPA, the CPRA, the CDPA, the CPPA, both the Canadian Draft Law and the California Enforcement Agency, we now seem to have the CPA. We can only wonder what acronym the Connecticut Privacy Act can use once it adopts one. That is still in the remote future. Today we focus on the new privacy rules in the Centennial State, and tell you more about what to expect from July 1st, 2023. My name is Paul Breitbart.
And I'm Kay Royal, and welcome to Serious Privacy. So, Paul, I had a good question picked out today for the unexpected question, but I decided to go with another one.
You always do that.
Yes or no? Everyone should have a backup plan.
Yes.
You had to think about that one for a little bit.
Well, I can imagine that your follow-up question is going to be, what is your backup plan? So I was considering whether I would feel comfortable in confirming whether or not I have backup plans for certain things.
You know, I like the philosophy of people who say, you know what, all in, doesn't matter if you have a backup plan, just go for it. But, you know, maybe it's the personality of attorneys, risk averse. I think we always have backup plans and backup plans to our backup plans. There's always alternatives.
Just in case, because you never know what's going to happen.
You really don't. I think the one time I didn't have a backup plan is when I moved to Arizona. I'm pretty open. I learned to be open about this because it helps other people, but I'm pretty open with the fact that we ran to Arizona for me to escape a psychotic husband. And so when my children and I hopped on a plane and flew to Arizona, there was no backup plan.
Well,
that was it.
That was the backup plan.
And it worked out okay, so I think we're good. It worked out okay. All right, so today let's dive in and talk about Colorado. And I've got an informal poll going around asking for what should be the name of the Colorado Privacy Act, because CPA, as you say, we're running out of words here. And I thought maybe Colorado Privacy Act, so COPA, and we can just call it COPA. But that's too much like...
That would be too close to COPA.
COPA, right? So why can't someone do a reverse acronym with privacy? The protect the rights of individuals very aggressively...
Rest assured, y'all.
Oh, my goodness. Okay, so let's talk about Colorado. So Colorado did pass their Privacy Act on June the 8th. Typically, and under Colorado Constitution, and I think you just said this and explained, but under the Colorado Constitution, the governor typically has 10 days to sign, veto, or let it ride. But that's only if legislature is in session. If it's not in session, he has 30 days. And with Colorado was supposed to end their session on June the 12th. They ended early on June the 8th, literally passed this as one of their last acts. But regardless, even if it was to end on June the 12th, that still didn't leave him 10 days to sign. So he has 30 days to sign, veto, or let it ride. And rumor has it he's going to sign it.
Okay. Just to let it ride. I mean, doesn't a law always need a signature from the highest operational authority, the highest executive, to become really law? I mean, just doing nothing and then it assumed to be a law, that it's strange.
Yeah. You would think it would be if you don't veto it, it's vetoed after 30 days. But no, this is if you do nothing, it passes. And that's pretty typical.
But this is not ubiquitous in the United States.
I think in most cases it is. It's the opposite for the president. The president can do a pocket veto, essentially means he puts it in his pocket, and because he didn't sign it, it doesn't become a law on the federal level.
Which would make sense to me.
I believe that there are states that have that as well, but more common than not, it's a pocket passing rather than a veto. And that actually helps in many cases on the political ride, in the fact that at least someone can't accuse a governor of actually signing the law. But I mean, the fact that he doesn't veto it is an action in and of itself. So there we go. Political maneuvering.
So what's the law all about?
So what the law is about, and this is interesting, it actually brings in a lot of elements of both California and Virginia, or through Virginia specifically, elements of the GDPR. There was one particular language when they talk about if their processor doesn't follow the controller's instructions and takes affirmative action making decisions for data, they would then be considered a controller. That language is straight out of the GDPR. I did not look up to see if it's actually in Virginia's, but it's straight out of the GDPR. So there's a lot of things that are very similar. A lot of things that there's some misinformation going on about there. One of the big misinformations being that the governor has 10 days to sign it. So the governor might think he only has 10 days to sign it. Who knows? But they technically, by the Constitution, he has 30 days. But some of the other things are interesting. One of the other misconceptions that I've seen out there, and by some law firms that I absolutely respect, is that the definition of sale is more like Virginia, being for pure monetary gain, other than California, which is money or other valuable consideration. Nope, the definition in Colorado is for a sale is other valuable consideration. Money or other valuable consideration. So you have a good blend here among what we're going to see. And I think this is actually going to be what we're going to start seeing, and what we've been afraid we're going to start seeing is the states aren't going to align with each other. You're going to have lots of different connotations and nuances and differences among the states that may actually wind up be very difficult to manage.
And that is also part of the criticism, right, on the Colorado Act, especially the question whether the opt-out is really effective, because it only seems to be aimed at targeted advertising and sale of information.
And profiling.
But not to other elements of data collection. And the IAPP actually quoted Amy Stepanovich, who is currently executive director at Silicon Flatirons, saying you can't opt out of the unnecessary or irrelevant collection of your data, only out of targeted advertising, sale of information, and profiling. So it is going to be useful, but how effective is this law really going to be to protect individual rights?
Right. And I would say the response to that is we're moving in the right direction. The states are granting individuals more rights than we've ever had. And so at least it's not moving in a worse direction. It's moving in a more positive direction for privacy people. And so I think eventually we will start seeing more alignment on a global basis. It does make you wonder, though, that if we do have a federal law, as you've heard me say before, I'm afraid it's going to be a very weak law. And it's not actually going to even include a lot of these standard rights that we're seeing. But they do say in the Colorado that you're only allowed to collect data that's relevant. And so your concerns but you can't opt out of irrelevant data. So one of the duties on controllers is duty of purpose specification, that they have to specify the express purpose for which personal data are collected and processed. Data minimization. It must be adequate, relevant, and limited to what's reasonably necessary in relation to the specified purposes for which the data are processed. So there are these duties on controller to not collect the irrelevant data. So I get what you're saying is, well, we don't have a way for them to opt out of it, but technically businesses aren't supposed to be collecting.
So what can I as an individual do about it? Well, I guess that I as a European individual can do nothing about it, given that these laws, probably like all the state laws, don't apply to me. But say I would be a Coloradan or Coloradoan or whatever I would be called if I lived in Colorado. Say I live in Colorado and I want to file a complaint or enforce my rights. What can I do?
It would be filing a complaint to the Attorney General. So the Attorney General and the district attorneys are the ones that have enforcement authority over this, and the fines under this are actually pretty strong. So if you were to read the Colorado Privacy Act, you wouldn't see the penalty amounts of $2,000 per person or per transaction up to an annual limit of $500,000 per a series of transactions. So if you had, 20 consumers, or if you had 2 million consumers, you would be able to calculate there. And that's because the Colorado already has a section of their law labeled the Colorado Consumer Protection Act. And under that, they have a lot of other areas of law they've already enacted, especially things like the breach notification law. So the actual penalties available are underneath those, not specified in the Colorado Privacy Act. So you'd have to go to Article 1 of the Chapter 6 for the Colorado Consumer Protection Act and look at that one in order to see what the penalties are. But they can also do a injunction to stop companies from doing things. And in the first 18 months, they have the ability to, if they want to, give a company notice of a violation and give them 60 days to cure before they take action. Now, that's an optional measure. And so they're not required to give notice. They're not required to give 60 days to cure. But regardless, 18 months after it goes into effect on January 1st, 2024, that goes away. So the Attorney General's office will no longer be able to give notice to cure. I guess that's 18 months of giving companies time to become accustomed to what's a violation and how to fix them and have guidance put out.
Bit of a transition period.
Exactly. And I do think the opt-out mechanism is going to be interesting because of the way that they phrase the opt-out. And in my mind, and there might be better minds than mine that disagree with me, but it seems that the opt-out is actually giving the technology the ability to be considered an authorized agent. So let me see if I have this specific language here for the opt-outs. So the opt-outs, as you've already said, will only apply to the sale of data, to targeted advertising, and to profiling, which we've already talked about. Mm-hmm. But the opt-out itself is they have to provide a clear and conspicuous method, both for consumers or their authorized agents, to opt out in the notice as well as an accessible location outside the notice. But the authorized agents may indicate the consumer's intent through web links indicating a preference or browser settings or extensions or global device settings. And by phrasing it that way, it seems as if the technology would be considered an authorized agent itself, which when you think about it, there have been pushbacks on authorized agents because companies implementing technology, let's just use TrustArc, for example. If you had to opt out for TrustArc on your website and people use that to opt out of certain things, that wouldn't be considered an authorized agent because they didn't provide us a notarized letter appointing us as their agent that we could then submit to the company for them to prove that we have the right to act as them. And so I think this is an interesting way of putting that the technology would then be authorized because the person put in the settings themselves, even though it's a third party providing that setting to the company to opt out.
So,
did that make any sense?
I think it did. I'm still trying to get my head around how complex US legislation is. And you might probably say the same about European legislation. Don't get me wrong, but having been brought up in the European legal tradition, and especially in the continental European legal tradition, and not the common law system, this all seems very complex and convoluted and trying to make sense of all of it. But I do think that I start to understand what's going on here and how all the differences work and overlap and not. When talking about enforcement, you mentioned that an individual can go to the Attorney General and file a complaint. So
Yes.
I take it there is no private right of action?
There is no private right of action. As a matter of fact, it is very specific that not only is there no private right of action, you cannot use a violation of the Colorado Privacy Act to underpin any other lawsuit you may file to allege that a company has done you wrong. And we've already seen that happening in California because the CCPA also states you can't use it to underpin any other right of action. You can only have a right of action towards breaches. And you can't use the violations of the CCPA in any other way to underpin any other lawsuits. And there's a ton of lawsuits out there using the CCPA as evidence that the company did something wrong.
Mm-hmm. So it is still happening.
It is still happening, yes.
Yeah, so talk to me about special categories of data. Does the law say anything about that?
It does. We have a definition of sensitive personal data. They call it sensitive data, not sensitive personal data, but sensitive data is personal data revealing racial or ethnic origin, religious beliefs, mental or physical health condition or diagnosis, sex life or sexual orientation, or citizenship status, genetic or biometric data that's processed for the purpose of uniquely identifying an individual, or personal data from a known child. And they define child as someone under the age of 13. And so if you were to compare this across the board as to what of our definitions of sensitive data, so Colorado lines up pretty well with California in many of these regards, or with the GDPR in many of these regards. Where you're seeing a big difference, of course, is the political opinions and the philosophical beliefs. Union membership, California and GDPR both have those. Citizenship or immigration is not in California and GDPR, but it is in Virginia. So we have that. It also has, of course, the genetic, biometric, the personal data from a known child. Although GDPR doesn't classify that as a special category of data, we know that there's a special Article 8 for that.
Well, that only refers to consent by minors, so...
Right, and to information services.
Yes.
Exactly. So there are those, but it's interesting how they're defining this, because the one on mental or physical health, so Virginia specifies it has to be a diagnosis, whereas under the others it's condition or diagnosis.
And I would assume that includes the process of coming to a diagnosis, right?
I don't know, given American law, you can argue over every single little word here is exactly what it means. Yeah.
That is concerning, to be honest, because if you are still in the process of being diagnosed or being told that you have a certain condition, all that data could still be up for grabs. Well, of course, there are still other laws that protect it to some extent, but...
Exactly. There are other laws that protect it, and Colorado actually has a fairly extensive list of what is excluded from the Colorado Privacy Act. And so most of the data there would probably be excluded under the other, which is really good. Well, Colorado has condition or diagnosis. It's Virginia that doesn't. So most of it would be. And so you do have to look at how laws act together. And that's one of the complicating factors of U.S. privacy law is not easy to understand anyway. In Europe, it seems relatively simple. I know the law is not, but it seems relatively simple. It applies to all personal data. It applies to basically every entity that processes personal data. Very simple. You got a health condition, it's going to be protected because it falls under GDPR for personal data.
You're going bankrupt, it's protected.
It's protected. So in the U.S., though, you may or may not be protected. Are you a consumer of a certain federal type of services? Do you have health care? Do you have financial? Are you a student? And if you're a student, do you receive government funds? That's the only way you fall under FERPA. If you're a patient, your doctor isn't necessarily under HIPAA. Most people assume it is. It's not. And one thing you might not be aware of, Paul, under U.S. data, and this is interesting because this is in my part of what I'm covering in my dissertation, there are student medical campuses at university campuses. There's usually a student medical clinic or something. Those are not covered by HIPAA. Those fall under FERPA for the education rights, and it's considered a treatment record, and it can be shared in more ways than what HIPAA would be able to share. Therefore, it is a big point of contention when someone experiences a crime on campus, such as being raped or assaulted, and they go to the medical office to get treatment, and then they may turn around and try to sue the university, and they find out their medical records have been shared to the legal office. Well, that can happen because that's one of what's allowed under FERPA for treatment records. Under HIPAA, it wouldn't be allowed. But FERPA and HIPAA, FERPA provides an exception for HIPAA records, and HIPAA provides an exception for FERPA records. And if you're at the campus medical clinic, you're probably going to be under FERPA, not HIPAA. And people assume that their data is protected under HIPAA because it's medical data.
Wow.
Yeah, I thought you'd love that one.
Yeah, I thought I was getting my head around U.S.
Then I had to throw you another one.
legislation, and yeah, you threw me another bone. So you touched upon it, but is this really a case of better something than nothing, or is it really a good law?
For the U.S., I think it's a good law. I mean, frankly, any states passing any privacy law are going to be good laws because they're moving in the right direction. Does each of the state laws do everything we would want them to do as privacy professionals? No. We have not yet landed on that magical formula, but I do believe the Colorado one put a lot of thought into what they're doing. I can't even disagree with a lot of the exceptions that they have in place, because it eliminates some of that confusion. They're giving companies a ramp-up period. They're requiring controllers to put in privacy notices and to stick to minimum data collection and notices. They're requiring the opt-outs to be in 2 places. They have very specific requirements for processors, and they have a requirement for data protection assessments to be done, which the Attorney General can request. So you have to do data protection assessments, and if you do them and you get a complaint, the Attorney General is able to ask you for those completed data protection assessments. And not only that, he can use those data protection assessments to determine if you violated any other laws. So that's an interesting one I haven't seen. So I do like that. And the processors, it's just like the GDPR. They have to adhere to the instructions of the controllers. They have to assist in meeting obligations. They have to ensure each person who accesses the data are under confidentiality provisions, so their employees and their contractors. Now here's an interesting one. They can only engage sub-processors only after giving controllers an opportunity to object, which is relatively new. Mm-hmm. And they have to, of course, have a written contract with them, and they have to, have security in place. So it's interesting, and the contracts have to also include those requirements as well as an option. I don't like the option, but the option to return or delete data when the termination of the contract. The processor to provide controller documentation to demonstrate compliance, and there are audit requirements in there, either to provide an audit report that's acceptable to the controller or let the controller hire an auditor or bring it in. I think the controller has to actually pay for the audit. So it's interesting that the elements they have a little different from Virginia and California, a lot of them overlapping, a lot of them very much bringing in GDPR. A lot of things in here that we do not see in what was proposed in Arizona. And so it might be interesting to see if other states are going to pick up from Colorado. Are they going to go the Virginia direction? The Colorado seems to be more alike. Are they going to take the California? Not having a private right of action.
Will they go their own way?
Will they go their own way? Do they have their own ideas of how things should be done, which is the way states are supposed to do? They can take specific measures because they know what's best for their citizens, just like member nation states in the EU can put in enhanced protections for that. I think we're going to see more that are going to not have a private right of action. And I think we're going to see more that are going to require impact assessments. Those seem to be two very consistent things we're seeing, as well as, of course, they're going to have consumer rights
and accountability requirements, even though they are not explicit.
Exactly. But we haven't yet seen another state-level consumer privacy agency, which they had their first meeting yesterday, the California Consumer Privacy Agency. But they're going to hire an executive director. Did they give any hints as to who, or are they just putting the call for the job out?
I wasn't in the meeting, so I haven't heard. I've only...
shame on you.
Well, this was most of my evening last night. There were other things I needed to do.
Oh, you mean like have a private life? Darn, Paul.
No, reread the SECs and work through the next series of blogs on the SECs.
Yes, so we will have the information on the Colorado Privacy Act up on the TrustArc blog. It is broken into 4 sections because it is quite detailed, provides the steps you need to take as a controller or processor to abide by it. So we'll have that on the blog as well. But we also have information on the new SCCs. So if you missed our podcast last week on the standard contractual clauses, which by the time we...
2 weeks ago.
Yeah, I was going to say it might be 2 weeks ago by the time we publish this one, because we do want to get Representative Domingo's Arizona information out there. But yeah, so we should have this information out there. Maybe by the time this podcast goes live, the governor will have signed it.
Who knows?
So we'll see. If so, we'll give a precursor to that and say it's signed.
Yeah, before we wrap up, because there is a lot of work that people need to do before July 1st, 2023.
Yes.
And this is 6 months later than the other laws that start in 2023. So there is a bit of additional time. What does this all mean for federal privacy legislation? Will this bring it any closer, or will it make it more complex?
I think it gives the current legislators more to think about. So in the details, because we all know the devil's in the detail, although the things that they argue about tend to be the private right of action and the federal preemption. And the Future of Privacy Forum actually put out a blog, very informative on federal preemption and what's available there. I don't know that it's going to move us closer to having one. I think it's going to make them think more.
So we'll see a bunch of new proposals for federal privacy legislation likely in the fall session, but it's unlikely that any of those will make it through to the White House.
I can't even take a good guess anymore, frankly. I don't know what direction they're going. I would like to think that they are still moving closer to having a federal privacy act, but with the new SCCs, that might actually impact the impetus that lawmakers here in the U.S. have to have a federal privacy law if the SCCs are going to eliminate the need for a data transfer mechanism if the company is directly subject to the GDPR. So, I don't know.
Well, only time will tell. And with that, we'll wrap up another episode of Serious Privacy, and thank you again for listening. If you like our series, please do tell your friends and colleagues about us, and rate and review our episodes in your favorite podcast app or on your favorite podcast platform. Also, feel free to retweet our social media or to reshare our LinkedIn posts. We always like that too. And should you have any questions or suggestions, especially if you would like to be a guest, please reach out to us via seriousprivacy@trustarc.com or via Twitter at @podcastprivacy. You will find Kay on Twitter as Heart of Privacy and myself as your Paul B. Until next week, goodbye.
Bye, y'all.
That was Serious Privacy.
If you're a data protection or privacy professional, you already know the pressure. Non-stop regulatory change, AI oversight, internal demands, and the expectation to somehow stay ahead of it all. And the old patchwork of tools just isn't cutting it anymore.
No. That's why TrustArc created a modern privacy management platform powered by Arc Intelligence. The TrustArc platform brings your workflows, evidence, research, tasks, and applications all together in one unified and intelligent workspace so you don't waste time digging, clicking, or context switching.
With Ask Arc, your privacy assistant, you can ask plain language questions about laws, jurisdictions, or even your own program data. and get credible, cited answers based on NIMBY research and more than 1,000 global laws. It's explainable, transparent, and purpose-built for data protection and privacy.
So if you need to add a vendor, create a cookie banner, or start an assessment, quick actions take formally complex tasks, turn them into bite-sized guided workflows to save you time.
It's a platform that thinks like you, works like you, and helps you move faster with confidence, whether you're a seasoned DPO or you're just getting started.
See how modern privacy gets done. Explore Arc at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.